Good morning, everybody. I'm Scott Brabrand with VASS. It's great to see many of you, and we're glad to be presenting here. We know we're just wrapping up the end of one year, but we're already pivoting to plan for next year. And one of the things that we've heard from superintendents across the state is getting the latest and greatest updates on Title IX. And you'll be learning from our own Micah Schwartz, who's our VASS legal counsel, what those key nuggets are around Title IX, 4 key nuggets you'll be hearing about. And this is important that we're bringing it to you now because these Title IX regulations will be effective August 1st. So we really are doing this to give you just-in-time information so you can spend some of your summer obviously taking a break, but also have an opportunity to begin to prepare your division for these new Title IX regulations. So we'll have a presentation from Micah. He's got a few slides to share with you. This presentation is being recorded, and it will be available for others of your colleagues who were not able to be on the call today. We'll also hopefully have time for some questions at the end. We won't run over an hour. We value your time. And I don't really think Micah's presentation will go a full 60 minutes anyway. So again, welcome all of you. We're glad to have you here for this VASS Title IX webinar. And Micah Schwartz, we'll turn it over to you and let you start your presentation, and then we'll take some questions afterward.
Sounds good, Scott. Thank you for the introduction. Good morning, everyone. So I'm going to try sharing my presentation now, and I'm going to assume that you can see it. I'll just launch into it. But if you can't, then
you can see it. Very good.
Can see it. Okay. Okay. Excellent. All right. Well, again, good morning, everyone. Let's get into it. Here's our agenda for the morning. First, I'm going to give a background on what I mean when I refer to Title IX. It's probably a term you've heard a lot, but I want to take this down to the studs so you can understand what I'm talking about when I say that there are new Title IX regulations which were issued by the Department of Education in April, which go into effect on August 1. So let me repeat that the new regulations go into effect on August 1st. That's less than 2 months from now. So that's why Scott refers to this as a summer project, because these new policies are supposed to be in effect when the school year starts. And then finally, I'll try to give some practical advice for dealing with the changes. Let me give some quick disclaimers. The first is that this is what someone I've heard recently refer to as legal guidance, but not legal advice. So obviously I'm a lawyer, and I am going to be interpreting what I think these regulations mean. But I'm not giving legal advice specific to your division, because giving good legal advice means tailoring the laws to your particular division and your policies and your circumstances. And obviously I can't do that with 50 different divisions at one time. So I would still recommend discussing this with your legal counsel or whoever you turn to for altering your policies. And then finally, there is a training requirement under these new regulations, which I'm going to talk more about in a little bit. This presentation is not intended to replace that training requirement. What I'm going to explain soon is that you have to train all of your employees, and I would recommend that you undergo that training as well. Technically speaking, this would probably qualify because the obligation is really just to kind of understand Title IX better. That's what the rules require. But there's also a need to understand your own policies better, to be trained on them. And again, I can't do that for 50 divisions at once. So I would still recommend that you undergo the training that you're going to give it to everybody else in your division. Okay, with those disclaimers out of the way, I'll get into the meat of it now. So what just happened? The U.S. Department of Education issued new Title IX regulations. They are called, or they refer to, non-discrimination on the basis of sex in education programs or activities. That's how the U.S. Department of Education considered these regulations. In more layman's terms, what that means is that the federal rules which dictate how schools respond to allegations of sex discrimination have been changed, revamped. And those changes, there is some kind of lead time on this. They didn't go into effect immediately. They go into effect on August 1st. So again, you've got about 2 months to adapt your policies to these new rules. So I want to explain what the new rules are, but I think I need to lay a little bit of a foundation here first. And I hope you'll bear with me. I think this will be interesting, and I think I hope it'll be interesting. I think it will help you understand the changes better, because you really need to understand the progression of all of this over the last couple years. So let's start from the literal beginning of this, which is the Federal Education Amendments Act of 1972. This is what that law said. No person in the United States on the basis of sex, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So in simpler terms, what that means is that any entity that receives federal financial assistance, which includes every school division, right? So in other words, every school division is prohibited from discriminating on the basis of sex. That is what the statute actually says. This is very similar to other non-discrimination statutes that were enacted by Congress in the 60s and 70s. This is the one that applies to education institutions. It is the primary federal law that prohibits discrimination in schools based on sex. As you will see, a lot gets thrown into this bucket. The idea of prohibiting discrimination on the basis of sex ends up becoming the basis for so many rules that we deal with, including what I'm going to get into soon, which will seem probably pretty far out on a branch when you consider that the statute here is actually just referring to prohibiting discrimination on the basis of sex. Okay. Since its inception in 1972, which is over 50 years ago, I think what most people, at least people outside of the education industry, think of when they think of Title IX is its requirement for gender parity in high school and college sports. At least in 20 years ago, if you had asked somebody, what do you think Title IX means? Someone would probably tell you, right, that's the thing that requires that schools have equal numbers of girls and boys sports and equal resources for both sports and things like that. That was what Title IX meant, I think, for most people up until about 15 years ago. Things changed in the early 2000s. And I think the reason why is because the US Department of Education identified this problem, I think primarily in higher education. But what was intended for higher education, as you'll see, applies to K through 12 schools as well. The concern was that there was rampant sex harassment and sexual assault on college campuses. And the Federal Department of Education was looking for a way to address that. We are at this point already in an era, this is going to be a theme of this presentation, where Congress isn't enacting a lot of laws in this area because there's already hyperpolarization. And so what every administration, at least dating back to the Obama administration and probably even earlier, is doing instead is not trying to pass new laws, but rather trying to reinterpret old ones to reach the ends that they want, or to create new programs, new requirements based on language that's already in statute, because it's hard to get new statutes because Congress can't agree on things, or at least the executive branch in Congress can't agree on things. So from this comes something that is referred to amongst Title IX lawyers as the Dear Colleague letter in 2010. This is during the Obama administration. And it is the first kind of official federal guidance which says this statute, which I described a couple of minutes ago, the thing that prohibits discrimination on the basis of sex, means a lot more than just prohibiting men or women from coming to your college or having unequal levels of resources in sports. It also requires heightened concern for sex harassment and sexual assault. And the focus here is primarily on women. And the logic here is if women, and again, I think it's easiest to think of this in terms of higher education, if women in colleges are facing such high sexual harassment or sexual assault, then they cannot receive an education on par with their male colleagues. And as a result, there is discrimination on the basis of sex happening in higher education. So you universities need to crack down on this at your schools. And if you don't, we're going to investigate you. That's the sea change that happens in 2010. Again, it's interpreting discrimination on the basis of sex to apply to something which isn't even a university decision. It's just how students are treating each other and how the universities are responding to it. Again, I think that's what the Department of Education is focusing on when they get this ball rolling about 15 years ago. But again, all these rules that were initially intended for primarily focused on higher education apply to K through 12 schools as well. When the Obama administration did that in 2010, they didn't issue regulations. Instead, they just issued guidance. And I want to try to explain quickly what those things are. Guidance is just a suggestion from an agency. And I'm not trying to be glib about this, but just to give you kind of another example, the model policies that come from the transgender model policies from the Youngkin administration, it's guidance, right? That these are suggestions, maybe with some teeth in them, but it's not law, right? It's not a statute and it's not even a regulation. As a result, it can be changed very easily. This is the kind of thing that a new administration can change immediately. That's different from regulations, which are not quite as ironclad, let's say, as law, as statutes, as things that Congress enacts and a president signs, but they're the next best thing. And the reason why is because they require, it's harder to make them and it's harder to change them. And what is required for regulations is something called notice and comment, and I won't belabor this point. But the idea is that the federal agency and also a state agency, if they're doing it, has to provide notice of what the new rules are going to be, and then an opportunity for the public to comment on it, and a response to those comments, and then an enactment of the regulations. And those are harder to change because if a new administration wants to change them, it has to run that whole process over again, and that could be time consuming. So prior to 2020, all we have in this area is guidance. Again, it's the guidance that is provided by the Obama administration in 2020. A major change happens in 2020 when, for the first time ever, the Federal Department of Education issues Title IX regulations. So again, this is now not guidance, this is basically law that schools have to follow. And because it happened during a conservative administration, it reflects that administration in some ways. It is, well, I'll explain what I mean by that in a minute, but it is a pendulum swing back. The Obama administration, as I described a moment ago, was very focused on the experience of women in colleges in particular, and what was keeping them from being able to get an equal education on par with their male, other male students. The Trump administration's Department of Education swings the pendulum back a little bit to less of a focus on complainants. And in this case, trying to rectify what it believed at the time was kind of a hypervigilance towards this type of sexual harassment and sexual assault, which was leading to primarily male students being kicked out of schools too easily. And that's obviously kind of like a glib way of describing it, but that was the focus of the administration, I think, at the time, which was that we've gone too far here. Schools, in their attempt to do what the Obama administration was asking them to do, have kicked men out of colleges too easily. And so we need to provide new protections for them. So that's what the Trump administration's rules look like. But remember, again, this is for the first time not to just guidance. It wasn't something that could change easily. Instead, it was actually regulations. And this is what the 2020 regulations included. And you've probably received a presentation like this a couple years ago. This is, again, a pendulum swing in the other direction. And it was something that we all had to take very seriously because, again, for the first time, it was in regulations. Now, I think a lot of divisions probably didn't do this in the first place. And so what I'm about to describe in a few minutes is a pendulum swing back to something that is less intense. And if you all never made the changes in the first place, then you're in a comfortable place because you can just maybe keep doing what you've always been doing. But this is what divisions were supposed to be doing, at least since 2020. Those regulations included these key terms. One, an elimination of what we call the single investigator model. The Obama administration's guidance said that there has to be a Title IX coordinator, somebody who was coordinating this whole process and investigating allegations of sex harassment and kicking kids out of school if they committed sex harassment. The Trump administration, as I said, was more focused on kind of what it considered to be overkill, basically, and trying to add due process back into the system. And what I would say is adding layers of process and adding more people to the process to just make it slower and also eliminate any bias that might be in the system, again, towards kind of an over concern with kicking respondents out of school when they're accused of things. So again, we're in 2020 here. This is what the regulations said at the time. Schools could not have what was called the single investigator model, which I think you all would probably call just discipline as usual. That's what I'm going to call it during this presentation, in which somebody, a building administrator, investigates an allegation, determines whether it's true, and merits out punishment based on it. That was not supposed to happen in the sex harassment space after 2020. What we needed instead was something that was much more kind of trial-like. And the investigator and the decision maker could no longer be the same person. There had to be someone who's investigating these allegations, putting together a report that would then be considered by a decision maker. And this is what I'm calling layers of decision making. We're adding more people to the process to make it basically harder to kick a student out of school. The 2020 regulations also required hearings. Again, more process and a system that Department of Education at least thought was going to be better at determining what was actually the truth. Usually in sex harassment situations, and again, I think the model here is sexual assault on college campuses. That's the birth of all this. Those circumstances are usually he said, she said circumstances in a dorm room or a fraternity house in which there's no one else who's there. And when these situations come to the attention of the Dean of Students office, all they have is the two accounts of the alleged victim and the alleged wrongdoer. And so the 2020 regulations required hearings to try to determine what actually happened. Because the concern, again, was that deans of students were just kicking men out of college too easily without giving them due process. So the 2020 regulations created these hearings that were necessary. But not only, again, in colleges, we had to be having hearings in K through 12 schools. Next, there had to be an opportunity for appeal. So let's say, again, you had a overly biased investigator who was too quick to believe the truth of an allegation and expel a student. We're adding process here to try to eliminate that bias. So we add another decision maker, and then now we add an appeal. So there's at least 3 people who were involved before a kid gets kicked out of school. There was a higher standard of proof at that time, clear and convincing evidence, which is, again, I'll just say it's a higher standard of proof. It was not enough to just say, well, we, the university, or we, the school, think that this is what happened. We think it's more likely than not that this sex assault occurred, so we're going to kick the kid out of school. No, the 2020 regulations required a higher standards of proof. It wasn't beyond a reasonable doubt like we have in the criminal space, but it was clear and convincing evidence. It had to be obvious that this actually happened. And then finally, respondents weren't able to be punished until there had actually been an adjudication of their claims. So a presumption of innocence until proven guilty. All right, so all of that, thank you for listening to that background. That is all the law up until April. This all changed in April. To bring it back, I think, to something that will actually seem probably more familiar if a lot of this is news to you. Okay, so as I mentioned, when the Department of Education issues new regulations, it has to issue them first as a proposal and receive comments. So that happened in 2023. What we have now are actual final regulations. They were issued in April, and they will go into effect in August. These, of course, are the product of a more progressive administration. And so they reflect what you would maybe expect to be the focus of that administration. And I'm putting up these pictures of the politicians who are involved. And I obviously don't want to overly politicize this, but I do think to understand, like, why is this happening? Why do we keep going back and forth on this stuff? I do think politics is a big piece of that. So you have to consider who's in office at the time when these things happen. So what we have now is a pendulum swing back again, something closer to what I described as the Obama administration rules from 10 years ago. But it's not as big of a pendulum swing. It's still going to look like the rules that I just described a minute ago. It's again trying the idea here is hopefully that the pendulum swings are getting smaller and we're starting to kind of settle on something that everyone can agree on. But this is a return to a focus on complainants with, I would say, less of a concern on the due process rights of respondents. Okay, what does that actually mean? Scott referenced 4 headlines. This is what I'm thinking of as the headlines here. Sorry to bury the lead. I know we're 20 minutes into it, but I think I needed to provide that foundation first. So these are the headlines. There is no more hearing requirement. The kind of the heightened due process that I described a minute ago, that is weakened now. I think this is back to discipline as usual, like I said a minute ago, and I'll explain more about what I mean by that in a minute. We are also now able to return to the single investigator and decision maker model, which means you can have one person investigating the allegations and that same person making decisions on guilt or innocence. You don't need to have 2 decision makers. You also don't need to have appeals anymore. So all this can be done by one person as opposed to, say, 3 people. While the process is simpler, the things that get this heightened process, on the other hand, are going to be greater. Because for the first time, we have sex orientation and gender identity being included in these regulations. I'll explain more on that too. And then finally, now everyone needs to get training. Before now, it was just the investigators and the decision makers who needed training. Now everyone needs training. Okay, let me give some more detail on what I mean by these things. So there is no more hearing requirement. As I just explained, the 2020 rules required hearings. In the university setting, they had to be live, meaning you needed trials. What we had in K through 12 settings were what I'm calling a paper hearing, which means something that was kind of intended to mimic the process of a trial, but people didn't actually have to get in the room to do it. Instead, investigator could just talk to the complainant, talk to the respondent, make a report, do things like what a trial would look like, but with the parties separated. So this is a particularly big change for universities who no longer have to do these live trials. I think it's probably a smaller change for K-12 schools because you weren't doing the live hearings in the first place. As I said, the 2020 rules have this due process focus. There was an adversarial model for adjudicating claims to try to get to the truth. And to give some more detail of what I mean here, both sides had to be provided with the evidence presented by the other side. So if there were emails or text messages or interview notes that an investigator took during the process, the investigator had to share that information with the other side. And then the other side got to pose questions back to the other side. Again, this is kind of, imagine a trial, right? In a trial, you have a witness and let's say the superintendent poses questions to that witness, and then the other side gets to cross-examine that witness. This is what was supposed to be happening over the course of the last couple of years. It was possible for schools to do this on paper as opposed to in a live hearing, but nonetheless, we had to be giving, over the course of the last couple of years, respondents the opportunity to cross-examine the complainants, meaning, investigator, I want you to pose this question to the complainant. Isn't it true that the complainant was wearing a crop top at that time? Isn't that true? And the investigator was expected to ask that question of the complainant in kind of a trial-like style. We don't have to do that anymore. There's no more obligation to have a hearing. There's no more obligation to provide each side with the other side's evidence. And there's no more obligation to allow for this kind of cross-examination. Instead, you can treat allegations of sex harassment and assault more like how you handle other kinds of discipline issues. So this is what I am thinking of as what I'm calling back to discipline as usual, meaning you can now treat these allegations like you treat other things. And this, I think, when I say this, it'll be like, yeah, right, this is what we do for everything else. This is like, and maybe what we were always doing. This is what I'm envisioning is your discipline system. A building administrator, or maybe somebody in central office, or maybe even a teacher, investigates an allegation, draws conclusions based on what he or she learns, and then implements punishments accordingly. I'm guessing that is how you handle discipline in other cases. For instance, when you find out that two kids have gotten into a physical fight, or if you learned that one student was calling another student a racial slur. This is how I am guessing you handle those kinds of situations. And you can now, once again, do that with sex harassment and sex assault allegations. If there is one headline to this whole thing, it is that you can treat sex harassment allegations more like you treat other discipline problems. There's no need to provide each side with evidence that they can use to cross-examine the other. There's no need to allow them to be part of interviews with the other side. Instead, you can just investigate and draw conclusions and punish or remedy accordingly. Okay. Headline number 2, return of the single investigator model. So as I mentioned before, the 2020 rules added not only more process, but just more people to the process. And again, I think the idea here was when you add more people to the process, there's less opportunity for someone to get railroaded. Meaning, and again, that this is the concern here is you have I'm just going to like say it because I think it's easier to think of it this way. You have a Title IX coordinator who is hyper concerned with boys harassing girls and is kicking the kids out of school, boys out of school quickly. That is the thing that the 2020 rules were designed to try to prevent. Maybe that wasn't happening in the first place, but I think that's what the 2020 rules were designed to prevent. We're just kind of chilling out on a lot of that now. So now you can go back to having, again, a single investigator and decision maker, meaning building administrator investigates the allegation of sex assault or sex harassment, draws conclusions about whether or not what's alleged really happened, and tries to remedy the situation as that person seems appropriate. It used to be the case, again, over the course of the last 4 years, that an investigator could do those things, but had to provide a physical written report that they then provided to a decision maker who would read it and decide if they agreed on it, and then ferret out the punishment. And if one of the parties didn't like that, they could appeal that decision to another person. In most school divisions, I think that's usually, say, like principal, would say be the investigator. The superintendent is the decision maker, and that decision can be appealed to a school board. We don't have to do all of that anymore. Now you can just have one person who investigates and makes decisions. Again, the prosecutor and the judge can be the same person. Under the old rules, they had to be different people. Let me make one more point on this before I move on, though. You do still need to have a Title IX coordinator. That was a creation of the last, let's just say 15 years or so. We had to have these Title IX coordinators. You still need to have a Title IX coordinator. But that person can be doing everything. If you're a small enough division, that person can be investigating almost all, if not all, of these allegations, and then also making decisions based on them. So you still need to have a Title IX coordinator, but you can have that person doing all of the roles that I've described. Whereas before, the Title IX coordinator wasn't supposed to be the investigator and also wasn't supposed to be the decision maker. Okay, so the bottom line on this process is that we have simpler procedures for investigating and adjudicating claims. The process here should be simpler. On the flip side, there are more things that are going to get this Title IX treatment. So again, I would say everything that I've described is probably a little bit more intense than discipline as usual, but not a lot more. But it's a little bit more difficult, and it's going to continue to be a little bit more difficult in even more areas, because now we need to consider not just sex harassment and assault, but also sexual orientation and gender identity. So let me explain what I mean by that. These heightened procedure requirements that I described from the 2020 regulations were just for sex harassment and assault. And again, I think the idea here was these are particularly sensitive circumstances. again, picture again, we're talking about a fraternity house in a college. They are he said, she said, they are very contentious. They're very sensitive. There's usually no witnesses. And the outcome that the victim wants is usually for the other student to be kicked out of school. And so we need to have a lot of process for managing these. But we don't need to have a lot of process for managing, again, all of the other stuff, right? Meaning the fight, even the racial slur, or even other kinds of sex discrimination. Meaning I wasn't able to enroll in that class because that teacher doesn't like girls. That's sex discrimination, but it's not sexual assault or sex harassment. Under the 2020 rules, all of this procedure that I was describing was just for adjudicating sex harassment and sex assault. The new rules require this heightened process for all kinds of sex discrimination. And this includes, for the first time, discrimination based on sexual orientation and gender identity. This is a somewhat controversial topic because if I can go back, I do this quickly, all the way back to what does the statute say? All of this is about interpreting what this 1972 law says. And the law only says this, basically, you can't discriminate on the basis of sex. And I think undoubtedly, when Congress used those words 52 years ago, they meant discrimination against women. But the Department of Education has expanded the definition of what on the basis of sex means to include now discrimination on the basis of sexual orientation and also discrimination on the basis of gender identity. And these concepts are getting pulled into this regulation for the first time. So now what I'm describing is kind of, say, this discipline as usual, plus a little bit more bells and whistles. We now have to apply that treatment to more things. Now it's not just sex assault and sex harassment, but rather any allegation of sex discrimination. And that, let's just say it again, that teacher didn't let me enroll. I wasn't allowed to enroll in the student newspaper class or to participate on the student newspaper because the teacher who leads that class doesn't like girls. Or also, I wasn't able to participate on the student newspaper because the teacher who runs the newspaper doesn't like gay kids. Or finally, I wasn't able to participate on the student newspaper because the teacher who runs the student newspaper doesn't allow for participation by transgender students. These kinds of allegations 2 months ago did not require this heightened process because they were not allegations of harassment or assault. They were just allegations of different treatment. Now, under the new regulations, all of these kinds of allegations need this heightened process. So we need to be investigating allegations of sex orientation and gender identity discrimination just more intently, I'll say, than was necessary before. Let's focus for a minute on gender identity in particular. The regulations say that schools cannot deny transgender students from selecting facilities based only on gender identity. Again, the regulations are they're just broader here. They're no longer focusing just on the procedure for sex assault and sex harassment allegations. They're promulgating more rules about how schools are going to interact with students, and in particular, how they're treating transgender students. And what it says in particular is, again, basically, kids get to pick the bathroom of their choice, and can pick the bathroom that aligns with their gender identity, even if it's not the bathroom that aligns with their biological sex. That was already the law in Virginia because of a court case from a few years ago called Grimm versus Gloucester County. So this, I would think a lot of school divisions have already kind of incorporated this idea. But if you lived in another state, this is kind of a bigger change for them. And it's a meaningful change for us nonetheless, because it's now a part of federal law. As I should say, as as issued by the Department of Education. So the stars are kind of starting to align here. We've got case law that says we have to do it. And then we also have federal regulations which say we need to do it. The stars are aligned in another way, at least temporarily because of these regulations. Because the regulations say that schools can still require sex separation in sports based on biological sex, meaning schools don't have to allow students to participate on sports teams based on their gender identity, if that gender identity is different than their biological sex. So again, to put it in even simpler terms, you don't have to allow the transgender girl to swim on the girls' swim team, or to allow the transgender boy to play on the boys' baseball team. You can still treat students based on their biological sex when it comes to sports. So for a nice little period of time here, I would say the stars are aligned. All of the authorities that we have to follow here are telling us basically the same thing, which is that you don't have to allow students to play sports based on their gender identity. That is the rule of the model of the Youngkin administration's model policies, current model policies of the Virginia Department of Education. And it is also effectively the rule of the VHSL. The VHSL rules say that school divisions can make this decision as they see fit. And the VHSL provides a application process if a school division wants to allow a student to participate in a sport based on their gender identity. And the VHSL will adjudicate that and might say no, but I think more typically says yes. But if that's not what a school division wants, if a school division's preference is to just have kids participating on sports based on their gender identity, based on their biological sex, then they don't have to apply for a waiver to the VHSL if a parent asks for it. And they are complying with, again, these Title IX regulations and the Virginia Department of Education regulations. So again, all of the stars are aligned right now to say that if you don't want to allow transgender sports, you don't have to. That might change soon, however. We have proposed rules already from the Biden administration, which would require schools to allow transgender participation in sports in some circumstances. But the Biden administration, it appears that they are not going to try to finalize those rules in this term. And it is, rumored that this will become a part of a second term of a Biden administration if there is one. And that makes complete sense because, again, they've already proposed these rules. They're just waiting to finalize them. But I don't think that's going to happen in the next 5 months. So at least going into the next school year, I think, again, the stars are aligned. You don't have to allow transgender participation in sports if you don't want to, at least not based on gender identity. Okay, so that's the gender identity piece. And then finally, the final headline here is that everyone needs training. Before now, you only needed to train your investigators and your decision makers on what this whole Title IX thing was. Now all employees need training. But the training that they need is training that they're probably pretty much already getting, which is they need training on the division's sex discrimination policies. And what that means is they need training on what the division's policies are, which prohibit sex discrimination. But also what I think is going to be the important add-on here, basically who they're supposed to tell if they see something that they think is sex discrimination. So if you do annual non-discrimination training, I think it's going to be pretty easy to add this in. But you do need to give some thought to kind of how do we ensure that we're complying with this Title IX training regulation, because we do now need to be training all employees on our Title IX policies. As before, investigators and decision makers are going to need heightened training. In terms of options for training, you have a few here. Your board counsel can do it. I do Title IX training for school divisions. And if you have a board counsel that you use for your legal matters, they can probably do this kind of training. I think the VSBA might provide, I think there's a good chance the VSBA will provide Title IX training. I think there's a good chance that VACOR is going to provide Title IX training. And then finally, there are a lot of vendors that have come into existence over the course of the last several years because there's so much more need for training in this area. There's just more people providing the training. So there's a group out there, for instance, called Grand River, which provides training in this area and even provides personnel if you need it to kind of help with your, if you need more people to help run your Title IX program, they provide personnel to do it. So you've got a lot of options. I'm happy to talk offline about how to find a trainer to do this training in particular. Now's the part of the presentation where we have to go through this question of kind of like, is any of this even going to happen? Because we're just in this new era. We're not dealing with federal laws signed by the president, which are going to go into effect unless they're unconstitutional, and that's rarely the case. We're in this new world order that we've been living in for so long, you probably don't even recognize it anymore, which is we're not dealing with laws. We're dealing with interpretations of what those laws mean by a federal agency. And that provides the opportunity for a lawsuit based on whether or not that agency's interpretation is in keeping with what the statute actually says. Meaning, is all of this stuff that I've described today required by those simple words in the 1972 law, which just says we can't discriminate on the basis of sex? Lawsuits were filed the day that these regulations were issued. One of the litigants was the Virginia Attorney General. And in particular, with that lawsuit is focused on the transgender parts of the rules that I described a couple of minutes ago. And the argument that they're making here, and I just mentioned this because I think it's interesting and worth giving some thought to, which is have we gone like off the reservation here? Are we too far removed from that language from the 1972 Act, which just prohibited discrimination on the basis of sex? Because we're now saying what those words mean. Again, if you wanted to present the most direct assault, I guess, on this rule, would be to say, now we're saying that boys get to use a girl's bathroom if they want to. And in fact, their right to do that is protected by that 1972 law, which was undoubtedly enacted for the purposes of protecting girls and ensuring parity in education. And now it's being interpreted to allow boys to use girls' bathrooms. And so some will make the argument that that is just too far removed from what that statute means. In other words, the Department of Education doesn't have the power to do this because they're no longer giving fair interpretation to those rules. They're just stretching it to mean what they want it to mean. That is the argument basically of this litigation. There are multiple lawsuits. Again, our very own Commonwealth is a party to one of them. The purpose of them will be to cancel these regulations, but that hasn't happened yet. And the regulations go into effect on August 1st, which is what, 8 weeks, 7 weeks away, about there, right? So not that far. So, you could gamble and say, I don't think these things are ever going to go into effect and we don't want to deal with them. So maybe we'll just wait to see. I have to refer to that as a gamble. I think given that, again, August 1st is less than 2 months away, we can't be certain that any court is going to cancel these regulations before they go into effect. So I think the more prudent move is to assume that they will, and to be ready for them on August 1st. So that means with this summer, I would recommend that you go back to your non-discrimination rules. They are probably listed in your manual, not as Title IX regulations, but rather just part of your non-discrimination policies. And I say that because when the VSBA issued model policies 4 years ago, they were just revisions to the general non-discrimination policies. So that's probably what you've got. I recommend going back to them, and I think they're going to need some revising, basically some simplifying. Again, I think this should be easier for school divisions. You can take a lot of the procedure out of what you've currently have in your policy so that you're dealing with sex harassment allegations more similarly to other kinds of discrimination allegations. Since I mentioned the VSBA, I don't know that they're going to issue a whole new set of policies, but I am confident that they are going to look at their policies and try and give some analysis to what would need to change in them. So I think more likely it's probably not going to be a whole new policy, but rather some proposed revisions to the current policy. I would recommend looking at your policies and whatever the VSBA provides, if you're on the policy services program of the VSBA, I think you still need to take that to your board counsel or legal counsel, some attorney at some point, to ensure that it's actually what you want your policies to look like. And then finally, I'll final thoughts here. What does all of this mean? And then we'll break for some questions if you have any. Sex discrimination is still this special thing that needs more thought. It's still kind of a special treatment for sex discrimination claims by students, or I should say, and by teachers. I think a light bulb still needs to go off in your head when you hear these allegations, because again, they need more process. And now there's even more things that need that treatment, which is sexual orientation and gender identity discrimination. So again, there's more stuff in the basket, but the treatment is less special. We don't have to have trials anymore. This can look more like discipline as usual. So more things get the Title IX treatment, but the Title IX treatment is a little bit watered down. Okay, thank you everybody for listening to all of that. That's all I've got in terms of slides. If there's questions, I'm happy to take them. Amy, I don't know if I haven't been looking at the chat bar, so if there's some that are listed, we can turn to those, or however you Amy or Scott, however you'd like to manage this.
Well, thank you, Micah. We appreciate your legal knowledge and insights. I know it was informative, and we will send this presentation out, the recording and the PowerPoint at the end of this presentation. There were a couple quick questions, Micah. One was, what if you're in a mid-investigation, August 1st? Is there a grandfathering clause to those? Do you keep the old way or do you switch over to the new way? That was one question from Scott Warren. Okay,
yeah, it's a good question. I think that the best way to think of this is you apply the rules. Well, let me put it this way. Use the rules that would have applied from the time of the allegation. Actually, I think probably to be even more precise about it, from the time of the alleged misconduct. Basically, if the harassment occurred at any time this summer, or let's say in the spring, at the end of the last school year, you're still going to apply the old rules. Okay. Because the complaint was made when those rules were in effect. And these new rules apply to new complaints starting on August 1st.
That's pretty clear in a way. The new regulations aren't till August 1st. So until then, any incident would be treated under the old way with that more formal process.
That's right.
The other question was just about training. You mentioned VSBA, but I think in the chat it was shared. VSBA is doing training at the end of the month around this, and has shared that out with the school board members. And certainly we definitely encourage you to work with your board and make sure they're aware of that. And we'll continue to have Micah and the VSBA legal counsel work together on any of these issues around Title IX. We also have shared out in our weekly newsletter, AASA, the National Association, has been doing some work and has produced a guide around the new Title IX regulations, and that will be something we've had in the newsletter weekly, and we'll continue to have that information available in the newsletter around Title IX resources. Let's see if there are other questions that folks have. We have a few minutes left before the hour. Does anybody else want to raise their hand? And Amy, if you can check if anyone wants to raise their hand or put it in the chat, we'll be glad to take any questions for Micah. I think the bottom line, Micah, really is August 1st, we're going back more to business as usual for our usual discipline process. However, more stuff is going to go through that usual discipline process, and everyone's going to need to be trained. So if you've never trained your employees before, you need to be thinking about some form of training. I know you mentioned VSBA. You also mentioned VACORP, and there may be others. People need to be aware of when these complaints come forward, even though it'll be more like usual student discipline. there will need to be an investigation, even if it is just a single person doing the investigation and the final decision. So we wanted you all to have this information. We hope it's helpful. Please feel free to reach out to any of us on the VASS staff or to Micah if you have additional questions. And we really appreciate you spending time with us this morning, and hope everybody has a wonderful summer. And if we get additional updates over the summer around this, we'll certainly share them with you. And I think, Micah, to be honest, this will be something as we continue to implement into the school year. We may have you bringing updates at our fall conference or at another webinar if the need arises. So thanks, everybody. Have a great day, and we'll see you soon.